and I also serve as the Parliamentary Caucus Chief Whip, and which is why this moment is very important for us to communicate with the South African public. So I want to thank the media houses who are here and also thank the colleagues who are streaming live. For those who are online with us, we welcome you and thank you so much. In whatever platforms, and I'll leave it to the technical colleagues who are able to let us know how people are interacting with us, that becomes very, very important. A couple of weeks ago, and I believe it's in the first 2 or 3 weeks that we were in Parliament, we posed a question. As you know, there are different instruments in Parliament that you can utilize to make the voices of South Africans heard, through to the minister, to the president, to the deputy minister. I'm hoping that all of you are paying attention to the parliamentary quarterly program that is currently underway. If you're not, we're very happy to share it with you because that really unpacks what happens in Parliament and why it's so important, and the advent of the outcomes of the 29th of May election, what those have meant, and how actually the ripple effect of the developments that have followed, particularly the constitution of what is called the Government of National Unity, which we also call a grand coalition, because the nuances are very important to keep in track with, because the media is responsible in a I'm so sorry, because that's also a very serious problem. So I don't know who's going to help me dispose of the phone.
I think you disposed of it pretty well.
I apologize about that, but it is protected, so it's not going to crash. It's very important that we keep in touch with the parliamentary program that is released on a quarterly basis. We are in the second term of that. But the constitution of the Government of National Unity has meant that there are certain activities that have taken, sort of a hurried processing, because unlike in other parts of the governance structure in our country, government, in the national government, has got very serious legislative precepts that says we have to only do things in particular times and within a particular framework. The reason why we're here as ActionSA, we have said that we are going to occupy the space of the constructive opposition. We're not just going to oppose for the sake of opposing. We are going to hold those who have said they are going to constitute a government for us. We're going to hold them accountable, and we're going to make sure that this is going to be a very different dispensation. We've heard the president in his opening of Parliament and the various speeches that he has made since the beginning of the 7th administration, that this is going to be a different administration. What do we mean by that? The president has promised that we are going to be a more accountable government, or that the GNU is going to be a more accountable government. But the reality is that, accountability also goes with the instruments of accountability and who is going to hold the current 7th administration accountable. So we as ActionSA have called this press conference to really speak to you about the things that we have promised. It is very important for political parties, when we are on the campaign trail, the things we say, the things we promise to the people of South Africa, that we keep on with that. It's a very difficult task, I have to tell you, because the issues that affect South Africans are so many, so vast, so deep, and so concerning. And so to have a tracker as to what it is we've promised South Africans and what it is we actually get to do is a work of serious science, commitment, and determination to come out on the other side and be able to communicate with you at different points in time. Now, the reason why we are here because you remember that prior to, just before the 29th of May, there was the issue with the Ezulweni saga that plagued Luthuli House. Everybody saw that Ezulweni, attached particular assets of the African National Congress, particularly Luthuli House. We also saw that particular furnishings, all sorts of things were coming up against the Luthuli House, particularly the African National Congress, because of the amounts of monies that were owed to this particular company or organization. We were one of the first companies to delve deep into this issue and want to have it resolved, and also want to hold not only Luthuli House, the African National Congress, who were also still ruling the governing party at the time. And I'm hoping that as we move along, colleagues, we will be able to really traverse the waters around this ruling versus governing. We don't have rulers, we have governors. As a nation, because we're not a monarchy, we are a constitutional democracy, and therefore those who are elected to preside over our government are governors and they're not rulers. And so we remember that the Ezulweni saga happened, and then as soon as we could all blink, the debt to Ezulweni was paid. So we are here because we were one of the organizations that, and I think the only, Michael, if I'm not mistaken, that really took this issue to task. Mm-hmm. So my colleague Michael is going to speak to the technical aspects of what we have really gone through up to date. I'm just going to give you the background around particularly issues of the Political Party Funding Act. Now, this is not a lecture. As you know, you all are journalists, and you've all understood the precepts and the reasoning behind the Political Party Funding Act. We know that, the act was officially promulgated or enacted on the 1st of May in 2021. What was really the reasoning behind that? The reasoning behind that was the reality that we as a nation have been dealing under a veil of not being able to know exactly what the motives behind political parties were. Why were so many political parties formed? Who's funding them, etc. And so the Political Party Funding Act really sought to improve things like transparency in political party funding. We wanted to regulate donations. The Act also wanted to make sure, following, and I think you all remember the group called My Vote Counts, which also played a role in this situation. And so what we wanted to do also, the Act wanted to make sure that the establishment of the multi-party democracy fund was also regulated. You may have seen us in previous times also challenging this multi-party democracy fund, because what it does, it does not necessarily look after political parties that are not represented in the National Assembly. Now, Michael is going to go through why this is important. The first thing that I want to mention is the fact that we have, as a political party, as ActionSA, since the inception of our organization, declared all of our political party funding, which other organizations or other political parties have used to or weaponized to say we are funded by so and so our mandate can't be on behalf of the South African people, that it is on behalf of particular funders. Now, the same political parties have not actually themselves declared who it is that is funding them. The key issue we all have to ask as South Africans is, if political parties do not adhere to the precepts of the Political Party Funding Act, then what happens to them? What is the sanction? What are the instruments that are available to the South African public to make sure that political parties actually do declare who's funding them? Because the weaponization of particular funders against certain political parties is not fair, if in fact other political parties who never even care to declare their funding and where they're getting their monies from, and the South African public is mute and immunized against those political parties, much to the detriment of those who are declaring. So now we want to question, what exactly is the purpose of this if it cannot be enforced? We've heard in the previous times when the ANC have said we've got great policies, for example, but the implementation has been dismal. Who then must check this implementation? And so we have called this particular engagement with the media and the South African people to begin to probe these things, because as a political party that has declared that we want to be one of the political parties that holds not only the state but also ourselves accountable to what we promise to the South African people, but also make sure that the South African people themselves also play their role in keeping political parties accountable, actually comes to fruition. And so I think in a short way, without wasting too much time, that is the background of why we have called all of you here today. I'm going to allow and ask my colleague, Mr. Michael Beaumont, to address you, and then we will traverse between one another, particularly on the things that and the points that I have raised and the points that Michael will raise, and then also deal with your Q&A thereafter. With that said, Michael, are we going to play chess, or how are we going to do this?
Just pass the mics, I reckon,
Pass
if
the
you're
mics.
comfortable with that.
Okay, great. Colleagues, if you may assist those of you who can, so we don't just...
One day what we'll get is like a sliding thing on the front
Yeah,
of
I
the
think
table,
we
you
need
just
to
kind of
do
move
that.
it.
Fantastic, thank you.
All right. Greetings, ladies and gentlemen, members of the media, ActionSA supporters, and people of South Africa who are following these proceedings from home. I welcome you and thank you for joining us today. It's for a particularly important reason that we are here today, though, because the Constitutional Court achieved a great victory for the people of South Africa when they ruled that the South African people must go to vote with the full and transparent knowledge of how political parties are funded, particularly in the context of a country reeling from the effects of state capture. It was a landmark judgment, and it required Parliament to develop an act that was going to give expression to that fundamental need for transparency. And I think what you're going to hear from us today is that the act and its implementation are falling desperately short of that standard. It's falling short of that standard because the onus is upon a political party to self-declare a donation, and anyone who believes that political parties in South Africa have earned the benefit of the doubt has been living under a rock for the last 30 years. The second point is that it places the investigative onus upon the IEC, which I think we can all appreciate is not an institution set up as an investigative body. It has no DNA as an investigative function. And in fact, it has just dumped it at the IEC's door. And I think of particular concern to us is the emerging pattern that for the IEC to take a matter forward, a party would really need to just come and confess that they've done wrong, and that really does make a mockery of what was intended by the Constitutional Court. And we're going to elaborate exactly on what we mean by that. But let me start by addressing the news headline that ActionSA is launching legal action against the IEC in respect of its continued failure to investigate the ANC Ezulweni Investments debt settlement agreement that was announced by the ANC in December 2023. And in addition to that, we have launched complaints to the IEC to require further investigations of two political parties in this election, that being the Economic Freedom Fighters and Umkhonto weSizwe, two political parties that if you look at their declarations and you look at their election campaigns, the one does not explain the other. And there is no way on earth that an institution can safeguard a financial investigative process like the Party Funding Act requires if the IEC is not going to pay attention to the fact that, for example, MK disclosed 380,000 rands worth of donations in this election in a campaign that must have cost them more than 100 million rand. If we aren't going to take that fact seriously, then we must really ask ourselves, what is the point of the Party Funding Act, and whether our Constitutional Court and its intentions have been grossly undermined in this process. But let me take you through these cases and why it is that we've adopted this position. In the 2021-2022 financial year, you will all recall that the ANC was in a position of financial hardship. Their employees were striking outside of their offices after non-payment for months on end. This was not an organization in a strong financial position to settle a massive debt agreement. At the end of 2023, Ezulweni Investments obtained a liquidation order against the ANC that fundamentally challenged the existence of that party. And then on the 22nd of December, the ANC, through its former spokesperson, Zizikodwa, made the announcement that the debt settlement agreement had been settled in full. It was a 2-line press statement, and I think members of the media may join me to share the view that the shorter the press statement, the more concerned we should all be as a country. It's important to note that the disclosures by the ANC during that quarter in question amounted just to 10 million rand. In the quarter in question where they announced the settlement of the debt, which was believed to originally be 102 million rand without the application of interest, which we will get to in a moment. Now, why is it that ActionSA believes that this agreement could not have possibly been legal? Let me explain why. For this agreement to be legal, the first thing is the debt settlement agreement could not have been discounted by more than 15 million rand. If that is the case, that would have amounted to a donation in kind, exceeding the annual limit imposed by the Funding Act. A market-related interest would have to have been applied since 2019, otherwise that too would be a donation in kind, because you cannot have a debt of that amount without the application of interest. And that would have to have been levied. By our calculations, we're talking about an amount much closer to 150 million than 102 million. For the settlement of this debt, any donor paying the account directly with the service provider more than 100,000 rand would have to have been declared as a donation in kind in terms of the letter of the Funding Act, and yet no such declaration in kind was made in the quarter, during, before, or afterwards. And it would have required no less than 10 donors donating each the annual maximum of 15 million rand to settle this particular debt. Now, why does this matter? Because we've seen commentary from ANC leaders who are saying this isn't a matter that should be bothering ActionSA. Well, it does bother us, because the ANC is a governing political party. When it makes a debt settlement in this quantum, and this is a massive amount of money, we have to ask the question whether or not the government is involved in solving this problem that belongs to the ANC, because let's be clear, there's been a track record of that in South Africa that one cannot ignore. For example, we have determined that Ezulweni Investments is a registered vendor in municipalities in KwaZulu-Natal that has received tenders at a local government level. This is a demonstration of the concern that we are talking about. It's also a concern that when the president and his majority in parliament before this election created a lacuna in law between March and May that effectively meant that there was a period where no donations would have to be disclosed at all, South Africans have to wonder, why was this lacuna in law created, and does it have any bearing upon this particular issue? It was in that regard that we wrote to the IEC on the 8th of January, lodging a complaint for investigation in terms of Section 14 of the Act. We are empowered to do so, and it is a matter codified in legislation. On the 10th of January, you will recall President Ramaphosa, in remarks broadcast by EWM, invited ActionSA to engage the ANC Treasurer General, Dr. Gwen Ramakgopa, to access the debt settlement agreement. He said it would be no problem. We wrote to Dr. Ramakgopa. We have never heard back in respect of that offer. On the 12th of January, the IEC responded to our letter, indicating that media reports are insufficient upon which to base an investigation, and that we should wait for the disclosures of that quarter to come out, because they had not yet come out. On the 1st of March, when they had come out, we again wrote to the IEC and said there's no way 10 million rands worth of disclosures can fund a market-related debt settlement agreement of 150-odd million rand. Please would they investigate? And on the 12th of March, we received confirmation by the IEC that said, quote unquote, the matter was being attended to by the IEC in terms of the relevant laws, which we and the rest of the country took to mean they were investigating the matter. From this point onwards, the IEC has ignored all correspondence, including the correspondence that we indicated was necessary for South Africans to vote on the 29th of May with the outcome of that investigation being known, consistent with the Constitutional Court's view that voters require transparency in these matters. As a result of the continued silence and blue ticks of the IEC, we issued a legal letter of demand last week, during which we required them to confirm the status of their investigation. We have subsequently received written response by the IEC to state that the matter is not being investigated as there's no prima facie case to investigate, in complete contradiction to the written correspondence we received on the 12th of March. Let's be clear, ActionSA is the complainant in this matter, and yet we've had to fight at every turn to get any information from the IEC about the matter of which we are a complainant. The fundamental principles of administrative law, which is the exercise of public power, like that of the IEC in relating to the Party Funding Act, must enable a litigant to be furnished with the information about how a decision was made, so that it can be tested in terms of its reasonableness and its rationality, if necessary, in a court of law. As a result of this, ActionSA will now initiate a legal action against the IEC that in its first instance will obtain the IEC's record of decision-making in this matter. In other words, the IEC is going to have to furnish us with the documentation and information that they use to come to the view that there is nothing to investigate here. In the one instance, if that involves the debt settlement agreement, we will finally have our hands on that agreement. If it doesn't involve the debt settlement agreement, you can imagine the case it makes for the irrational decision that you can rule in this manner if you haven't even viewed that document. And in the second instance, if necessary, we will challenge the rationality of that decision in the courts. We will follow this process and keep the South African people informed, because it appears that ActionSA is going to have to be a vital player in the world of generating discussions around transparency in the world of the Party Funding Act, if others are not going to play their roles. As it relates to the matters of EFF and MK, it's very important for us to state that this was a complaint we submitted yesterday, and obviously as such it is brand new. It is not anticipated that the IEC could have made any investigations into this matter as of yet, and therefore we must afford them the due space and time to go through their due process, which they are required to do. What we will say is the following. We have analysed the funding that both of these parties have received since quarter one of the 2022-2023 financial year, which you'll appreciate we're talking about 2 financial years ago. What it reveals in that time is that the EFF declared a total of 3.5 million rand worth of donations, and MK declared a total of 380,000 rand worth of donations. I think we need to have a frank and honest conversation as South Africans who have travelled our roads. We've viewed party posters, we've watched rallies on TV that were estimated to cost millions and millions of rands. If anybody thinks that election campaigns are funded on those disclosures, then I'm afraid we are living in an alternate universe. We have to have a frank conversation about those disclosures and whether or not those campaigns could possibly have been funded against them. The amounts declared in the tables raise the suspicion that the disclosures to the IEC reveal only part of the picture, and that the South African voters did not have the full picture when they went to vote on the 29th of May. If one looks at the costs of the EFF campaign, which we have embarked upon a process to cost, we indicate that it would have cost at least a minimum of 200 million rand, based on what we have seen, what the rallies cost, what posters cost. A lot of these things are done by service providers, shared between different political parties, and that way we have a very good sense of what these things cost. Similarly, the MK party ran a campaign that was seemingly very well funded, with rumours of funding in cash and even foreign funding, and yet they have only declared 380,000 rand for a campaign that was filling stadia, that was very well resourced in terms of branding, that involved expensive branded vehicles and cavalcades around the country. And it is very clear that this is a campaign that cannot be substantiated on the basis of the 380,000 rands worth of disclosures. The basis upon this particular complaint is to say to the IEC that requiring a political party to self-incriminate before you investigate is not adequate, and that any institution responsible for safeguarding a financial investigation has to ask itself the question whether the income justifies the expenditure. Ignoring that question is ignoring the fundamental purpose of the Act, which is precisely why we have taken this particular step, because ActionSA finds itself as part of a smaller and smaller group of political parties that continues to comply to the letter and spirit of this law, and yet we are the only ones who appear to be subjecting ourselves to that disadvantage. Mm-hmm. And this is a system that absolutely has to be investigated. If you would like to consider how incredibly ridiculous this has become, I want you to please consider the following. In the first 2 financial years of the Party Funding Act, a number of political parties, including the ANC, as I understand it, did not submit audited financial statements to the IEC as required by the Act. The implication of that is that there was no way of knowing whether or not they complied with the Act, because it's the audited financial statements that provide the verification that if a donation exceeded the amount, there was a corresponding disclosure. Without the audited financial statements, there's no way of affirming that that was actually adhered to. Those political parties were fined 40,000 rand. As a political party that follows the law, we spent 80,000 rand on our financial audit in order to get a clean audit outcome, which I must say we've now gotten every single year. And I can tell the South African people that the audit that we are submitting now for the financial year just concluded is again going to be another clean audit outcome. And in that particular way, you start to see the difference between political parties that are complying with this legislation and others that are simply just ignoring it, and they get away with it. And in fact, incur less expense getting away with it than we do complying with it. And you can understand just how unhealthy the situation is becoming. And we are willing to go all the way in respect of these matters, because we do believe the principle of transparency is an important principle. We think it's something that should be fought for, and we don't think that the Constitutional Court and the principles that underpinned its judgments should be undermined in the manner that we have seen here today, or that we presented here today. So from my side, this is the nature of the steps that ActionSA is taking, and we look forward to walking this step in hand in glove with the South African people and members of the media, reporting back the progress at every step of the way, because we believe that transparency and accountability are principles that must persist in the political system, and when they don't, we have to do something about it. Thank you very much.
Thank you, Michael. I want to come back here just to augment the transparency in political party financing. We have committed that we will be transparent with the South African people at all times. I just want to read you the submission that we made to Parliament just over 3 weeks ago, and we submitted thus. The Political Party Funding Act is crucial to maintaining transparency in political funding. A mechanism ActionSA maintains is necessary, which is why we have consistently complied with its provisions, ensuring that we report as required, which underscores our commitment to accountability. Unfortunately, this appreciation is not shared by other political parties that seek to circumvent political party funding reporting. This is evident in the ANC and many others that lack of adherence to these reporting standards, as shown by their recent efforts to undermine reporting thresholds entirely. ActionSA is alarmed by the glaring instance of circumvention when on 9 January 2024, ActionSA wrote to the IEC Chief Executive for Political Party Funding, Mr. George Mahlangu, seeking an investigation under Section 14 of the Party Act into the ANC settlement of over 102 million debt with Ezulweni Investments. The IEC responded stating that they would investigate the matter, but there has been radio silence since. ActionSA maintains that questions remain about the source of these funds and why they are not reflected in financial reports. In subsequent follow-ups, ActionSA applied for access to this information under the Promotion of Access to Information Act. Despite the initial response from President Ramaphosa inviting ActionSA to review the settlement agreement, the ActionSA Treasurer General has since refused access. On the 6th of August, ActionSA filed a parliamentary question, and we asked whether the Minister of Home Affairs, from which the IEC derives its funding, can indicate progress on the investigation into the African National Congress's settlement of the 102 million debt with Ezulweni Investments. If not, what is the position in this regard? If so, when will the South African people be advised on the outcome of the investigation? However, on the 22nd of August, Parliament indicated that our question would not be published, citing non-compliance with Rule 134, Section 5B for the following reasons. This is not an IEC question or investigation, but that of a private company litigating in a civil action against a political organization. This is a party political matter and resides between the two parties. If ActionSA is pursuing it on behalf of the company, it is not a matter that the minister is able to respond to. The legal process must take its course unless there seems to be undue interventions in the legal process. Private party political matters are not answerable to the minister. We oppose this view and will embark on an appeal process to get to the bottom of this matter. And so I read that into the record, and we will share that with you as the South African public. Now, one of the things that is of contention to us is how we are always able as a country to hide behind particular technicalities. Now, Joe Soap and Lerato Soap, somewhere out in Matatiele, has no idea what it is these technicalities are about. What it is that we need in this country going forward is we need transparency, we need openness, we need political parties as well as politicians who are about the people, who are not going to hide behind these technicalities as we are awaiting the volumes and volumes and volumes of state capture report handed over by the former Chief Justice Raymond Zondo to come to fruition. And so our purpose here today is to say those are not going to continue to be political rhetoric. We are going to hold the 7th administration accountable for its deeds. We are going to hold the current president of the nation, who was also the president presiding over the 6th administration, to account, irrespective of how the machinations of government, and I know you are all itching about Gauteng, however it is that that may transpire, ActionSA will maintain our position in terms of holding the administration, wherever it may lie, accountable for its deeds. Thank you, Michael, for your remarks. Thank you for listening to us. I will now open for a Q&A. And hopefully, please tell us the organization which you represent, with to whom you are posing your question, as well as your name, please. I will take 5. I will take as many as I can in the first round. If it's really, really burning, I'll